Good afternoon and welcome to the law. Today, we're examining the outcome of the suit involving the wives of Daddy Lumba, a case that has stirred debates on how Ghana's dual quote-unquote marriage systems, ordinance, customary, coexist under the law. At the heart of this judgment lies two critical lessons. First, that many citizens wrongly assume that ordinance marriages automatically cancel customary ones. And second, that Ghanaians abroad must understand the legal consequences of marriages contracted outside Ghana. With me are two seasoned litigation lawyers. They do other things, but for this purpose, this is how I introduce them. Rend of Chumesi and Iris Agri-Oliens. So, don't go anywhere. Stay with us. We'll be right back. So, which case are we talking about? This is a case in which Akosua Sewa Fosu, the plaintiff, herein seeks a declaration that she is the only surviving spouse of the late Charles Kwadwo Fosu, a.k.a. Daddy Lumba, and as such, the only person entitled to perform the widowhood rights of the deceased. She seeks an order from the court to restrain the head of family of the deceased from ever dealing with the second defendant, Priscilla Ofori, as spouse of the deceased, and a further order restraining Priscilla Ofori, a.k.a. Odobroni, from carrying herself as a surviving spouse of the late Charles Kwadwo Fosu, a.k.a. Daddy Lumba. The plaintiff alleges that she and the deceased married at the Civil Marriage Registry in Germany in 2004, and that their said marriage subsisted until the demise of Daddy Lumba on July 26, 2025. This is taken from paragraph 1 of the judgment of Her Ladyship Justice Dr. Dorinda Smith-Arthur, delivered on Friday, the 28th of November, 2025. And many of you have been talking. In fact, some talking without the benefit of the decision of the court. So, as we always do here, we give you platinum legal education. There's a lot to unpack in this decision as far as marriages are concerned, customary marriages, civil marriages, ordinance marriage, or call it, are concerned, and a couple of other things. So stay tuned in as my guests begin to help us unravel this judgment. Iris Agri-Oliens is right here in the studio. Maybe I should say she's no stranger to you. Good afternoon.
Good afternoon, Samson.
Thank you so very much for making time to join us.
You're welcome, Samson.
Great. Rend of Chumesi also has been on this platform a couple of times. Thank you very much, Randolph, for making time to join us.
Thank you, Samson. Thank you, Samson, for having me, and thank you for the opportunity to share some few legal insights on this matter.
And when I said litigation lawyers, I'm serious. I meant it. These guys are in court every day litigating. That's what they know how to do greatly. So, let's begin. What did the High Court's judgment in this case establish about ordinance marriage coexisting with, under Ghanaian law, with customary marriage under Ghanaian law? First, I think it's only fair to ask you guys to give me a brief of your reading, your introductory commentary about this case. So let me begin with you, Iris.
I would say that the judge took her time to explain, and I believe she did this knowing full well that this is a judgment that will be scrutinized over and over again.
You're right.
And she took her time to actually lay down, these are principles that we've already known, but because she knew that it was going to be scrutinized, she took her time to lay it down and explain it in such a way that it will be easily understood by the general public. So honestly, for this kind of issue, I wasn't expecting 74 pages,
right.
But yes, we have 74 pages because of the kind of scrutiny this judgment.
Is this a judgment you will celebrate?
I would believe so, yes. I think she did quite a good job with this judgment.
Okay.
Quite a good job with this judgment. Yes, there may be a question or two that you may not necessarily agree with, but she explained her position properly, and I think that it's worth celebrating.
Great. All right, so which judge are we talking about? I just mentioned her name a while ago. She is Her Ladyship Justice Dr. Dorinda Smith-Arthur. We will show you who she is right now on our screens. But, Renoff, do you share...
Yes,
do you share... I almost said yeah.
Well, feel free to call me, yeah.
Okay, great. Do you share in Iris's preliminary commentary about the judgment?
Yes, I do share in that commentary, and I also want to add that the judge actually deserves a lot of commendation for the yeoman's job she did, especially if you take your time to look at pages 31 to 33 of the decision. You'll notice that the judge took notice of the commentary that had surrounded the case and figured out that there may be a lot of people who do not understand the types of marriages we have existing in Ghana. So she decided, and you notice in the judgment, she said it herself, that because of the public interest in the matter, she will veer off the issues and take some time to educate the public on the types of marriages. So even before going to the substantive matters, she laid down the foundations for those who are minded to appreciate and understand why she has arrived at whatever conclusion she has arrived at. And she took her time to look at customary marriage, look at marriage under the ordinance, look at the Islamic or Mohammedan's marriage, gave the incidents of each of these marriages, and then proceeded to answer the questions that had been put before her as a judge to determine. So I think looking at it, and you also notice from your reading of the judgment that the judge actually anticipated every issue that may come up in commentaries and addressed it as well. So even after determining that there was a customary marriage between Lumba and Odo Bruni, she even went ahead, assuming that they were not even married, then she went ahead to give another alternative. So you notice that this is someone who really took her time to understand the issues, to understand the law, and to apply them to come to a conclusion that is more or less unimpeachable. So on that note, I think that she did a great job, and she deserves commendation for what she has done.
Thank you very much. And we discovered that there is a lot of interest on today's program. And so for those of you joining, we are happy to help you with Platinum Legal Education. And you're talking about, you are having lawyers who have what it takes to give you that pure legal education. So the first question I asked was, so what does this judgment establish about ordinance marriage and customary marriage coexisting under Ghanaian law?
So, as we all know, customary law is part of our legal system. Customary marriage forms part of customary law. And once it is, and everybody in Ghana, in the jurisdiction of Ghana, comes from a particular ethnic group.
Right.
And we've already had our practices before the passing of the marriage ordinance in 1884. So customary marriage and ordinance marriage are both recognized under the law. What it is that, or what now pertains is that people usually get married under customary law in accordance with their ethnic groups.
Right.
Then they convert that marriage into an ordinance marriage. So what happens is that it's no longer a customary marriage, but now becomes an ordinance marriage. In this case, what seems to have happened is that because of the failure to prove, I'm not saying that there was no civil marriage under German law. I'm saying the failure to prove, I'm choosing my words carefully.
That's right.
The failure to prove the civil marriage, we fell back on the customary marriage. So customary marriage, it will sit and be the default, where the ordinance marriage will come and cover that. So they can coexist in our legal system under certain circumstances.
So, Randolph, she says customary law is part of Ghana law, and that is constitutional, right?
That is constitutional. If you look at Article 11 of our Constitution, it clearly states the sources of law, and custom is one of the sources of law. I mean, custom to the extent, the customary practices to the extent that they do not conflict with the constitutional provisions are acceptable and applicable within our legal framework. So, I mean, the understanding that, and just to add,
I wanted to begin in plain street language. Explain to my grandmother. You guys are saying customary marriage and ordinance marriage. What are those?
Okay. So if I may just proceed on that.
All right.
Now, when we talk about customary marriage, and if I may permit it, is a marriage is a traditional marriages that pertain to each ethnic group or each tribe within the Ghanaian territory that we find ourselves. So for it, is a marriage to put it in local parlance, the marriage which happens among the families, strictly speaking, the one that we do in the house, the ceremony that we now what people erroneously refer to as engagement.
Correct.
That is what we refer to as a customary marriage.
So I was actually looking for the word engagement.
And it is not an engagement.
It's not an engagement.
It's not an engagement.
It is a marriage.
It is a marriage.
Customary marriage.
It is a customary marriage.
All right. Yes. Please proceed.
Yeah, so that is what we refer to as the traditional or customary marriage. And that in itself is marriage recognized by our laws and it has its own rights and obligations. It's fully recognized by the constitutional framework, the statutory frameworks. And once you are married under that and you feel that you don't need to move a step further, the law will accord you the respect and obligation and recognition as marriage without necessarily having to transition from that to another type of marriage. Right. So essentially, that is it. And I'll leave my learned colleague to talk about what the ordinance or statutory marriage is.
All right. Yes, Aris.
So with the ordinance marriage, that is what people refer to as we've signed it in court.
That's right.
Or they've gone to the municipal assembly or the district assembly. This is what they sign. Because ordinarily in customary marriage, although you have the ability to register your customary marriage, ordinarily we don't sign. But when they say the ordinance marriage, that's what they refer to as having signed in court or in church.
Great.
In a place of worship.
So I was looking for church.
Yes.
Because we are very familiar with that.
We are very familiar with that.
We do the engagement on Saturday or Friday. And then the next day, we are in church.
Good.
Doing what we call the white
wedding. Yes.
And then the churches have been certified by the state.
Have to be.
Okay.
Not every church is certified by the state.
Right.
You must have a license. So there are formal requirements that you must meet when it comes to an ordinance marriage, a marriage under our civil law. And you'll see that even though it is a church wedding, it is a secular marriage.
Okay.
It is not a Christian marriage. It is secular. It's fully statutory. Now, the officiating minister has to be registered as a person who can officiate the marriage. The place of worship has to be registered. You must necessarily publish the banns of marriage, which is that 21-day notice. After the publication of the banns of marriage.
The announcement.
The announcement, good. The announcement. After that announcement or banns of marriage, they would issue you with a certificate of publication. To tell you that you can go ahead and marry. And within 3 months of the announcement of the banns of marriage, you must necessarily marry. Otherwise, it means that that certificate has expired and you have to go through the process again. you must get married between 8 a.m. and 6 p.m. You must not do this after in the dark. And you must have 2 witnesses for each of the persons getting married. And then all of these persons will sign the certificate. So there are all these formal requirements. And this is particularly important because of the fact that there are a lot of churches in Ghana. And most of these start as little fellowships. They fellowship there one evening, a few evenings. Then they blossom into a full-fledged church.
Right.
Now, have they gone through the registration as a place of worship, which will be licensed to
have their ministers
also been licensed? All of these things are part of what would prove whether your marriage is valid or not. So ordinarily, you may think that you have been issued a marriage certificate, you have signed a certain document, but if you've done it at 7 p.m., we can prove that it's wrong. If you did not publish the bans, or even if after the publication it took you 6 months, that means that the bans that was published earlier has expired and it can no longer be held. So these are some of the things that
the church had not been registered,
exactly.
the minister
is not licensed.
All of that can affect the validity of the marriage.
Exactly, and you will see that the judge in her judgment also spoke about the fact that nowadays a lot of people have weddings at the beaches and at gardens and restaurants and hotels. I hope that they have actually ensured that those places are registered to hold marriage ceremonies.
Right.
And if not, they should have actually gone to do the signing of the certificate in the office of the registrar of marriages.
Ceremony there.
Then you bring your beautiful flowery ceremony there, and your marriage will be recognized under the law.
Thank you very much. So, Randolph, so why didn't the ordinance marriage contracted abroad automatically exclude the customary marriage in Ghana?
Okay, so Samson, to address that, let's even look at the issues that took Madam Akosua Sewa to court.
Right.
From a reading of her processes, her contention is essentially very simple, in my view, that she was married to the deceased Daddy Lumba under custom in 1991, thereabout. And then when they relocated to Germany or so, the marriage was converted to one of a civil marriage under the German law. In simple statement that I have made, contains a lot of legal implications. Madam Akosua Sewa now wanted the court to recognize her marriage to Daddy Lumba under the civil law of Germany. That is not a matter you can just walk to a courtroom in Ghana and throw at the court and expect the court to accept it. And the rationale, among others, for such proposition is very simple. The judge is sitting in the Ghanaian court, applying Ghanaian law, is not aware of the laws and practices of Germany, does not know the functionings and operational activities of Germany. So if you allege that you have contracted a marriage in Germany, and by virtue of that marriage, the customary marriage in Ghana or any other marriage contracted by the deceased Lumba cannot be valid, then you have assumed the burden in law to lead the requisite and legally permissible evidence to establish that indeed you were married to the late Daddy Lumba under the law of a particular country which prohibits polygamous marriages. This was what Madam Akosua Sewa was supposed to prove in court, to have the court grant her relief. But what did we witness? We witnessed a situation where Madam Akosua Sewa was unable to even first and foremost produce the original certificate of marriage. That is one. Two, we also witnessed a situation where after even the court granting her the opportunity, I think a 1 month period or so, to go and ensure that the photocopies that you have even brought to court are certified by the Ghanaian mission in Germany, was not done. And Samson, I've read a lot of commentary, people chastising the judge here and there.
Right.
But I mean, some of these people can be forgiven because they do not understand the procedures and practices of the courts. Samson, you cannot get up today and walk into a court in Germany and then profess Ghanaian law and expect the judge sitting in Germany to accept Ghanaian law if you are not able to prove that in that particular case, the applicable law is Ghanaian law. And that is the reverse is the case in Ghana. Mm-hmm. You cannot just walk into a Ghanaian court and expect the court to accept that. Because you are married to someone or because you have photos showing that you are married to someone in Germany, automatically that marriage should nullify any other marriage that the person claims to have entered into, even if you are able to prove. And we are talking about civil marriage. Mm-hmm. And like my learned colleague in the studio indicated, civil marriages are essentially documentary. So if your contention is that you have contracted a civil marriage, you might have the document or incidental documents to show. That is one. And two, because the documents are documents coming from a foreign country, and the judge does not have the direct access to get up and go and ask the country, is this coming from you? There are procedures that you must go through to ensure that the document will even be admitted into a Ghanaian court. The admission is only even raises a presumption that it is regular. It does not mean that the contents of it is true. Mm-hmm. But in all of this, our Madam Akosia Sewa and her team failed to even comply. I've seen some documentation, people are making the case that she went through certification. No, the certification is in two folds. It must come from the custodian of that document. And since the marriage was contracted in Boheim, Germany also, the custodian of the marriage register, the custodian in that case would be the registrar of marriages in Germany. Mm. He would have to issue you with a document and then certify it that as, even if you don't have the originals, and indicate that this is a certified true copy of the original. Then you take that document to the Ghana mission in Germany for them to certify that, yes, the officer who has stamped or signed this particular document is one, authorized by German law to sign such documents, and two, this is his particular position as of the day he certified that document. And that is all. And you couldn't do this. And by our laws, because your marriage is a foreign, that you are relying on a foreign marriage document, you're supposed to satisfy the requirements of our law before the judge can even admit it into evidence and even proceed to weigh it or determine whether to rely on it. And this was not done. So the judge had no obligation or had no right in law to rely on those documents, first and foremost.
Okay.
Now, and secondly, you were alleging that by German law, Samson, I don't know how well versed you are in German law. I am not a scholar in German law. And I doubt my colleague in the studio is also a scholar in German law. So by our laws and in the wisdom of the framers of our laws, they indicated that anytime you come into a Ghanaian court and you want to rely on foreign law, it becomes a question of facts. And it is best for you to bring an expert of that country to speak to those matters so that the court will be well positioned to understand what the law is and apply it if need be. In this case, Madam Akosia Sewa did not provide an expert witness from Germany to come and testify as to the legal implications of having a civil marriage in Germany. So as we speak, we don't know. We can only speculate. But in respect of this particular case, we don't have the position of the law on that matter. We don't have the position of the law on whether the documents provided were genuine or authentic or otherwise. We don't know. So in such a situation, you don't expect a judge who is seated to do justice in accordance with the law. And the law here means the law of evidence among others. That's to grant you your wish simply because you have come with some documents.
Okay.
And that is why I cannot understand why anybody will fault the judge for applying the law.
Okay. Thank you. Now, in Ghana, I hear it often said, we do substantial justice. If they have brought photocopies of the certificate of marriage from Germany, and there are certain things that must be done, as Randolph has explained, but those things have not been done. Maybe they have been done partially because it's in German, and then they take it to the Institute of Languages, then they do a translation and they show that we have done, and they bring it. Why can't the judge rely on that and say, oh, it's okay?
So when it comes to these kind of situations, if it was not in dispute, if that wasn't the point of dispute, then the judge could have looked at it. So, for example, she brought the certificate and then the defendant said, oh, I know that they undertook this civil marriage.
Okay.
Then all of that validity, because it's been accepted by the defendant, all of that is no longer an issue. But once a person has raised an issue or challenged it, then it's an issue for determination by the court. And the name of the game is evidence.
Right.
So you must produce sufficient evidence, and it must be done in accordance with the law. You will see that in the judgment, it appears that there was an attempt to get the German consulate to bring some letter.
That's right.
The difficulty with that situation, and the judge mentioned this, is the fact of some diplomatic immunities, in the sense that that consular officer or that German consul officer is not able to attend Ghanaian court and give evidence. And that is why it must have been done in the Ghana mission in Germany, so that you can call on them to ask them these questions of fact. So it's not as if you can just do substantial justice. Oh, let this go, let that go. No, it's not that wide, especially when it is a matter in issue.
There's an explanation you gave us before we started. It's the kind of explanation that, you know, ordinary people want to hear in very ordinary language.
Yes.
How did the judge come to the decision that both widows, both women are widows, are married, were married to Daddy Lumba?
So two things were not in dispute. The first one was that in 1991, Daddy Lumba and his first wife, Madame Akosua, contracted a marriage in Ashanti region.
Right.
The other thing was this, that sometime in 2010, Daddy Lumba contracted a certain marriage in Ghana. What is being said is that the case that had been brought was that because of the civil marriage in 2004, that 2010 marriage was was null and void, because you cannot contract another marriage after you have contracted a marriage under civil law. Now, how the judge resolved this, because the 1991 marriage was not in dispute, that remained.
Good.
What was in dispute was this 2004 marriage, okay? This 2004 marriage, because Madame Akosua was not able to prove it by evidence in law, properly so-called, being the authentication, being the certification by the Ghana mission, etc., that resulted in the failure of proof. So now all that is left is this 2010 marriage. Now, one of the issues that came up was whether Madame Akosua, by a certain letter, had admitted that the marriage had been dissolved.
Right.
Now, you'll see that Madame Akosua called an expert witness on Ashanti customary law, and that expert witness explained how dissolution of marriage is. So even if it is alleged in a certain letter that I have returned your head drink, that is the tirinsa, I've returned that head drink, and there is nobody to corroborate this, no family member who was there to accept these head drinks were there. How then do you go by that to say that Madame Akosua had divorced Daddy Lumba? You'll see that all of these issues were resolved, and then the only two things that were remaining was the fact that in 1991, Daddy Lumba and Madame Akosua contracted a marriage under Ashanti customary law, and then he contracted a second marriage, which he is permitted to do under customary law in 2010. And he recognized both of them and one of the other pieces of evidence was a certain video where, and this was supposed to have happened just last year, where he acknowledged both women as his wives. And that is how the judge arrived at that.
Catch a breather. We'll take a quick break. We'll be right back. This is The Law. It's your legal light. It is your help law. And my guests are Randolph Chumesi Ankra and Iris Agri-Oleans. We'll be right back. You're welcome back. This is The Law. It's your legal light. It is your help law. And my guests are Iris Agri-Oleans and Randolph Chumesi Ankra. They are helping us break down the judgment involving the suits involving the wives and family of Daddy Lumba. And we are very happy that you are very excited, you are enjoying it, and you like how things are being broken down. So let me return to here. So from what you have just explained before Iris came in, bottom line is that two central things were required to be done before the certificate of marriage photocopy would have been recognized. Those two things were not done as required by law, and because of that, it was not recognized. And Iris's explanation is that once that happened, the customary marriages that were originally, as it were, celebrated or procured are the ones that were left. And the judge had no option to hold that these two were marriages that could exist.
So if I may just add something there, just so that on why the judge, let's also remember that the issue of whether or not Lumba was still married to Madam Akosua Sewa at the time of his death also came up in the court.
That's right.
And the court, having found that there was Madam Akosua Sewa failed to prove monogamous marriage, now had to come and address the issue whether or not Madam Akosua Sewa is the only legitimate widow of Lumba. And then resolved that one and came to one of the issues which I think came up in the defense filed by the Busiapanyi as to the fact that at the time of Lumba's death, Madam Akosua Sewa returned the drinks. So, according to the family, by that return of the drinks and its acceptance by the family, there was no customary marriage between Akosua Sewa and Lumba. And the judge said, no, on the evidence provided, looking at Lumba's own statements, looking at the fact that under custom and based on the evidence given by the experts in customary law, that is not how marriages are dissolved under account custom or Asante custom. It's supposed to be done by the families. So Akosua Sewa herself alone, whether the drinks were indeed returned or not, lacks the requisite capacity to have returned those drinks. And therefore, because the customary procedures were not followed, that marriage was never dissolved. So that marriage also subsists. And therefore, Lumba, at the time of his death, the marriage he contracted with Akosua Sewa in 1991 was valid and subsistent. And because that marriage itself is also polygamous, because it's under custom, Lumba was at liberty to have as many wives as he could or as his pocket would allow him. And therefore, the marriage to, what's the name, Odo Bruni, is also valid and subsistent, looking at the evidence on record. So that is one of the, just to add to what my learned colleague in the studio has said, these are some of the reasons why the judge concluded that both women were wives of Lumba at the time of his death, because at the end of the day, the judge looked at the evidence that had been led by Akosua Sewa through her attorney, which is one Madam Georgina Osei Bonsu, and then Lumba's very sister, Bosom Pema also, and then the evidence led by the Busiapanyi, and the evidence led by the witness called by Odo Bruni herself, which is also instructive to know that the evidence, there was no evidence led on record, according to the judgment, to dispute the claim by Odo Bruni that she was married to Lumba in 2019 under custom. Madam Akosua Sewa's lawyer did not dispute that. There was no evidence impeaching that particular evidence on record. So once it was found that the marriage to the so-called stable marriage was not proven, then we have to come to the issue of whether or not there were any customary marriages subsisting. And the court said yes, based on the evidence, the two women are wives at the time of his death. Okay. And also to add to the issue of the substantial justice. Something I've seen and read a lot of people chastising the judge that she could have written to the German embassy for certification. That is not the job of a judge in an adversarial system. The judge is sitting, let me just use the layman's language. The judge is sitting here somewhere, and you have brought your case that you have evidence, and based on your evidence, this person is not qualified. And the person has also come in and said what you are saying is not true. Now you are called to prove, and proof must be proved in accordance with the law.
Right.
It's not everything that is evidence, and not everything that is even evidence that is admissible.
The judge is supposed to be an impartial umpire and not supposed to descend into the arena of conflict, as we say. Conflict. So it's not the job of a judge to go writing to people and finding out what should happen. Now,
exactly, that's what the judge's job.
From where you sit and from the work you have done over matters like this, what lessons stick out?
So, for the general public, for the general Ghanaian populace, it's you must understand what marriage is. You must understand, and especially for people who contract marriages outside Ghana. I know a lot of people go outside Ghana single and contract marriages for whatever reason. I'm not going to go into that. You must understand the validity of those marriages. I know people who divorce in Ghana, go and contract, divorce on paper in Ghana, go and contract. It's the nuances are there. We are not going to go into that. Okay. But you must understand that once you have divorced in Ghana, you are divorced. Once you are married there, you are married. You must ensure that your marriage has the validity of that state. As I have already mentioned, in Ghana, we have all of these requirements. Right. Definitely in whatever state you are getting married in under civil law or under their laws, there are certain requirements. Even if it is not a 21 bands, maybe it's a 14-day bands, whatever it is, you must ensure that you understand it, and then you understand the rights that are accompanied or accompany those marriages in order that you are properly covered. Otherwise, you might find yourself in a bit of a fix, and especially when it comes to your children and when it comes to succession. I've noted that in this case, there are children who are minors. And all of this hula baloo, honestly, if we all know that it's about property, there's no way anybody is getting or is filing all of these things for good health. No, for widowhood rights, no. It's about property. So you must understand how all of these actions affect you, affect your succession and your children. Our
phone lines are open. You can call and ask any questions to the lawyers. There are people who have asked a question, how do you expect two women to perform the widowhood rights? Is that difficult to do?
It's not difficult to do. Because,
why not?
Because widowhood rights is custom. And our customary laws admit of having more than one wife.
Good.
So it's you can perform widowhood rights. And you see, let us not confuse widowhood rights with succession. Succession has already been provided for under our interstate succession law. Although I must say that it needs some reform. Honestly, it does need some reform. But succession has been provided for. Once you are a widow, you should be able to perform widowhood rights.
Who do we have on the line? Hi, Samson, you're calling us from Laboni. Let's hear you.
Yeah, my question is...
Listen directly on the phone, not on your set.
Yeah, okay, Mom. So my question is...
Samson, we may have to drop you and go for somebody else. Okay, I'm sorry, we are unable to take Samson. This questioner says that, I disagree with Chumisi on the role of the judge. yes, it is not the duty of the judge necessarily to call the expert, but she has the power to do so. The law permits her to do so, especially when that became a central controversy she herself raised during the injunction proceedings. In CI 47, Spirit of Speedy, Comprehensive Resolution of Dispute, she should have gone ahead to call the German law expert to assist the court. The two lawyers disagree with you.
My question to the person who's asking the question is...
This is Edward.
Edward, which expert is this judge going to call? Are there a list of German law experts available to a court? Or is the judge expected to write to Germany, the Bar Association of Germany, and ask them for these? No, that is not how law or judges operate in an adversarial system.
Fred says that they are not just going to perform widowhood rites. They are going to have to apply for LA if he died intestate to administer the estate. That part must be managed well. Frederick, thank you very much. Who is on?
So, if I may take Frederick's question.
All right.
So, Francis, you notice that when this issue started, I was one of the very first people to indicate that this whole up and down is about inheritance or succession.
That's right.
And the law is very clear on how estate of a deceased intestate should be distributed. Even if it is determined that he had 5 or 10 wives, all the wives need not apply for LA. Whoever applies for LA, that's latest registration, under law, has a mandate in law to ensure that everybody entitled to a share of the estate gets their share. Right. Failing to do that in itself is an offense.
Okay.
So it doesn't matter who is named as an administrator. What matters is that whoever is named as the administrator ensures that the law is applied, the law on, that's PNDC law on one, in this case, interstates, is applied to the letter.
Right. In any case, you cannot have more than 4 making the application, right?
4 applicants, anyway.
Right.
You can't.
Thank you. Let me take Mensa. Where are you calling from?
Yes, sir.
Reduce your volume a
Hello.
bit. Yes, go ahead. Where are you calling from? Go ahead with your question.
Mensa, calling from Asifusu.
Yes, Mensa, it's you.
Thank you for that education.
All right.
But do more. We want more of those things.
Is that all?
Thank you, sir.
Is that all your contribution? Thank you very much, Mensa. That was short and titia, right?
It was.
Okay. Irene says that whether or not Odobroni has interest in properties acquired before her marriage in 2019, is that what you wrote? What did you want to say? Per my observation, most of the properties were acquired before her marriage. Do you understand what Irene is saying?
I think that she's asking about when it comes to the distribution of assets, how it's going to be distributed.
Right.
Now, if indeed the properties were acquired before the marriage of the second wife, that is
right.
Madam Priscilla,
right.
What will happen is that are these the self-acquired properties of the deceased alone, that is Daddy Lumba alone, or are they properties that belong to the two of them, that is Madam Akosia and Daddy Lumba? So those questions will have to be addressed before the properties.
So any properties they may have acquired as matrimonial properties exactly. Under the first marriage.
Under the first marriage.
Will not be liable or subject to, distribution.
No.
So not
for which
the
second wife can benefit.
No, not exactly.
Right.
So, for example, he has a house prior to 2010. Now, this house was built by both Daddy Lumba and Madam Akosia.
Okay.
Ordinarily, we are going to go with equality is equity. We are going to go with 50-50. Now, the 50% that belongs to Madam Akosia is not part of Daddy Lumba's estate.
Okay.
But the other 50% is part of Daddy Lumba's estate.
Correct.
So you'll see that
the second wife can now benefit
from a portion of that, included with her children,
right,
along with Madam Akosia, along with Madam Akosie's children.
Thank
of
you.
Just that 50%.
Yeah, hold on quickly. Who do I have on the line? Hello, Joseph. Where are you calling from? What's your question?
Yes, Joseph from Chifu
Chisupraso. Go ahead.
Yes, I want to applaud her ladyship during that data. Then only want to advise my niece that when there are marital issues which are unresolved, I think that if we cannot let the marriage continue, let's just dissolve it so that we can not wait until one dies and it creates all these controversies. Had it not been the judge who stood on the ground for this shorter period to deliver, you see that it was creating so many controversies.
Okay.
Then the expert listened. I wanted to ask the tester that would the court bear the cost of bringing the German expert? So I think it was a burden of proof from the plaintiff to bring the expert as the judgment.
Okay.
It was a fantastic judgment, and I think.
Thank you. Thank you. Who is next? Let me go to you because you wanted to say something. Hi, Randolph.
I just want to say that, on the point made by my learned colleague, I share that line of thinking. And I have always been of the view that a party or a spouse cannot be worse off in marriage, but better off in divorce. And I say so because our laws on divorce have been developed to the point where we presume that all marital properties are acquired jointly. And therefore, distribution of same should be on the principles of equity. Equality is equity. Right. And so you notice that the authorities will show that on many occasions where property settlement in divorce cases have gone up to the courts, either party ends up working with 50%. However, in a situation like what we have now, where parties do not divorce and death severs the marriage, you will notice that the right to inheritance of the surviving spouse diminishes from the 50% to a lesser percentage. So in this case, as my learned colleague has indicated, we are now going to talk about, even though the law is still gray on that side part as to whether, which I believe I'm of the fair view that can be pursued all the way to the Supreme Court for us to have finality on it, because I think that should be let me pick my very last caller.
Let me pick my very last caller and come to hear your final words of advice to all Ghanaians, all our viewers who are watching, whether Ghanaian or not, abroad or home. Hello. Michael, you're calling us from Kumasi. Go ahead, quick.
Yeah, Mr. Shafton, thank you so much for all that. I so much appreciate it. And I want you to bring back the legend, the Kokuba. That is.
Okay, thank you very much. I hear you. I think if I heard him right, he's talking about News 5. This is not News 5 politics. Kokubaku wants to take some rest. Allow him to relax. Right. So, lady and gentlemen, we would like to hear you in the next 1 minute each. What will be the lessons we should draw from this judgment as we go into marriage, as we go into either customary ordinance or marry abroad?
When I've already given a few lessons regarding understanding what system of marriage you are entering. One of the other things I'll say to a person is when you are faced with court proceedings, you must also understand what you are being required to do. You should be able to ask. I know people sometimes feel as if they cannot challenge their lawyer, but you should be able to ask, what is the judge requiring me to do, or what does the law require me to do? Sometimes that is how you're able to understand that burden that you have so that you can prove your case, rather than leave it for judges.
Am I hearing you guys saying somebody was let down somehow?
Well, I cannot sit in judgment over the work of a colleague, so I will not necessarily say that. But, reading from the judgments, you notice that several opportunities were given by the court for the right things to be done, which I believe should have been done, but wasn't done. So the judge was put in a situation where she had no option than to apply the law in a strict sense. And having made that point, I just want to, my concluding remarks would be that something, and this particular case is not unique, it's not unique to Lumba and Akosia Sewa.
Okay.
Fathers, mothers, siblings, friends, colleagues who find themselves outside the country. Most of them enter into marriages which now within the European context have been described as marriages of convenience or connection marriage. So if you enter into a connection marriage for the purposes of securing documentations and you achieve the purpose of that marriage, there is no point keeping the marriage on the records, because you may end up having this particular situation that today you will be insulting Lumba and Akosia Sewa over, because you may also have a subsistent connection marriage which was purely for documents, which will come back later, may come back and bite you because you failed to sever those ties.
Thank
completely.
you. Thank you so very much. So this discussion has shown that marriage is not just a personal union. It is a legal choice with lasting consequences. The Lumba case reminds us that ordinance marriages do not automatically cancel customary ones, and that Ghanaians abroad must be mindful of how marriages contracted outside Ghana interact with our laws. As our guests have emphasized, clarity in law begins with clarity in the education that we need. Citizens must understand the system they choose to protect their rights and their family's future. This has been The Law. It's your legal light. It is your health law. And my guests have been Iris Agriolians and Randolph Chumesiankra. Thank you all very much.